morning, everybody, and welcome to Estate Planning for Young Families. I'm Debbie Verney. I'm one of the attorneys at the Herzog Law Firm, and we're going to go through the slides about estate planning for young families. If you have any questions, feel free to type them into the chat bar, and we'll try to go through them as quickly as we can as we do the presentation. And if you have specific questions that you'd like to ask, feel free to reach out to me at D Verney, it's D as in dog, V as in victory, ERNI at herzoglaw.com, or you can give us a call at 518-465-7581. I'm at extension 122. And so let's get on with the slides. So when's the right time to plan your estate? It sounds kind of silly that anyone over 18 should have an estate plan, but that's one of the questions, right? Are you of 18 years old? Are you married or in a relationship? And do you have minor children? Okay, so those are the three of the main questions we're going to ask people if they're young and if they've not done an estate plan. So if you answered yes to any of those questions, then guess what? It's time for you to do an estate plan. So why do you need an estate plan if you're 18 years or older, right? You just graduated from high school. You're going to college, you don't really have any assets now. Why should you have an estate plan? Well, an estate plan is more than a will, right? An estate plan is a healthcare proxy, a living will, a power of attorney. Why are these things important? Okay, well, once you're 18, your parents, believe it or not, they're not control anymore. So all those phone calls that your mom made for you and things that she took care of for you, she can't do that anymore. But if your mom was your power of attorney, or your dad for that fact, they could actually make decisions for you, right? They could call up, check on your bank account and do things like that. If not, if they don't have a power of attorney, they're not going to be able to do things for you. Also, same thing for medical, right? They're not going to be able to call the insurance company, even though the insurance, like the health insurance, is in their name through their organization because you're still on their policy. They're not going to be able to call the insurance company without a power of attorney on file. And they're not going to be able to make healthcare decisions for you if there's not a healthcare proxy on file. When my son went away to college, I made sure that he had a healthcare proxy and a power of attorney. He felt, well, he really didn't need a will because he didn't have anything at that point in time. But I made him do a will anyway. It's better to have everything together, right? Just in case. That way you can set it and forget it. So again, wills, healthcare proxies, powers of attorney. If you're 18 or older, you should have all of these in place. So what if you're married or in a relationship, right? So a lot of times young people aren't getting married, right? So they're just living together. So the question is, if you're just living together, you're sharing expenses, let's just say you buy a house together. How are you going to take title to that house? You need to make sure that you protect yourself, right? Because if it's, for instance, joint tenants with rights of survivorship, then that means you die, it's his, he dies, it's yours. Or if you're tenants in common, then half of that house is going to go to your heirs. Or what if one of you doesn't have great credit and we buy a house in the one person's name and the other person's living there contributing to the mortgage, and then all of a sudden the person whose name the house is in passes away, right? Guess what? You're not married. Unless you've got something like a will, you have no rights. It's going to go to her family, right? Because if there's no will, right? If there's no will and there's a spouse, the spouse is going to get $50,000 in half and the children get the other half if there's children. But what if there is no spouse, right? No spouse, no kids, or maybe you're in a relationship and you just have kids. The kids are going to own your house. How do you feel about the kids owning the house that you're living in? These are a lot of things that people really don't think about when they're in a committed relationship, right? They're not worried about it. What if you have accounts, right? You each have your own individual account, and then you contribute to a joint account to pay bills. If something happens to that person, they become incapacitated, you're not going to have access to their account. So again, if you're in a relationship, whether you're married or not, you really should have some basic estate planning documents. Children, oh my gosh, children throw a whole nother monkey wrench into your planning, right? So what's going to happen to your kids? So you're married, something happens to both of you. Who's going to be the guardian for your kids? Who's going to be the trustee for your kids? Who's going to be in charge of their money? Who's going to be in charge of your children, right? So all of a sudden now these people have an extra couple of kids. What's going to happen if, say you're divorced, and something happens to you? There may be a situation, and I've seen it in the past, where you would not want your children to go to your ex-spouse because of legal documents and stuff like that. You definitely need to have someone out there that's your guardian, because if you don't have a will that says who you want to be your guardian, then the court is going to decide who the guardian for your children is going to be. And I would think that you would want to make sure that that was someone that you trust, right? Because if your parents step forward and his parents step forward, who do you want raising your children? So it's very, very important. And we're going to talk about the guardian here in another slide, but also trustee, right? This is all the money that your kids are ever going to have. So you need to make sure that the person you've appointed as trustee is someone that you're going to be able to trust with your money. I always tell people they should look at having the guardian and the trustee be a separate person, only because now this person who's the guardian has 2 more kids, and they're like, oh, well, we really should put an addition on the house, and maybe we should add a pool. And again, this is all the money your kids are ever going to have. They don't have parents anymore. So we need to make sure that that money is protected, that we have a trustee that's going to have some checks and balances with the guardian. Some people don't have a deep bench, right? Some people appoint the same person as guardian and trustee, which is fine, but you need to make sure that you have a backup, right? What if something happens to you and the person or persons you've appointed is someone that now all of a sudden their circumstances have changed and now they can't take your children? So definitely you want to make sure that you name someone you trust and that you have someone as a backup. So, as I said earlier, you need a will, you need a healthcare proxy, and you need a power of attorney. And we're going to go through each of those documents to make sure that you have that information together. So what is a last will and testament? It's a legal document that you sign, and it doesn't have any control or anything until you pass away. So you can have a perfectly good will, and if you don't have any assets individually in your name when you pass away, guess what? That will is not going to control anything. So if you're leaving $10,000 to care for your dog in your will, and then everything else has beneficiaries, guess what? There's not going to be any $10,000 to care for your dog. So you really need to make sure that there's language in your will, and or you make the person that's going to be in charge of your dog a beneficiary of, let's just say, a checking, a savings, a CD, or something like that, so that they're going to have money to take care of the dog. So when you're doing your will, you're going to name an executor. An executor is a person who is going to make decisions, collect the money, and then make the distributions to your beneficiaries. So people say, well, should I name my oldest child the executor? Who should I choose? That's up to you. I always jokingly say that you should choose someone that can balance a checkbook. Again, most people don't balance their checkbooks anymore. They log on every day and go, oh, look, I have money. Anyway, someone that has an idea with money, because the person that's the executor is going to have to do some research, right? They're going to have to find the assets. They're going to have to collect the assets. They're going to have to distribute the assets, and they're going to have to follow the direction that you put in your will. So you need to make sure this is someone that you trust again, and it's someone that has a kind of an idea about money and numbers. So what if there is no will? Okay, so if a person passes away, they're called intestate if they don't have a will. And New York State is the person that's going to figure out, well, not really, New York State's not really a person, but New York State is going to decide which people get your money. As we said earlier in the one slide, right? If you're married, they look to see spouse, kids, if no spouse, kids, parents, brothers, sisters, nieces, nephews, keeps falling down until they go to one first cousins once removed. If there's not one of those, then guess where it goes? State of New York. So when you're doing your estate plan, what if you have minor children? What if you have someone with special needs? What if you have someone that's very irresponsible? Do you really want that person to have control over your assets? Probably not. A lot of times we'll have clients that set up trusts for their children just because they may have a drug problem, they may have an alcohol problem, they may have a spending problem, and they set up trusts under their will for these people so that they don't get this big chunk of money all of a sudden and blow it. So these, again, are all things that we can look into and make sure that we have covered whenever we're doing your documents, but you have to do your documents. Intestacy law. So this is the law in the state of New York. And what it says is if you die without a will, they look to see if you have a spouse, then they look to see if you have kids. If you have a spouse and no kids, it all goes to spouse. If you have kids and no spouse, it's going to go to the kids. Pretty easy stuff, right? No spouse, no kids, goes to parents. No parents, brothers and sisters, no brothers and sisters, nieces and nephews, goes all the way down to first cousins once removed. You're like, wow, that doesn't make any sense. How could that ever happen? I had a client that was adopted, right? So she was adopted. She came in, she had done her regular estate planning, and then she was taking her entire family on a trip. Okay. So she said, I want to make sure that I'm covered because she was taking her only child, right? His wife and her grandson. They were all going to be on this plane, right? So let's just say she passed away. Let's say they all passed away on the plane. So you look, does she have a spouse? No. Does she have kids? No. Does she have parents? She has no idea who they are, right? She was adopted. Does she have brothers and sisters? No. Does she have nieces and nephews? No. Does she have first cousins once removed? No, she doesn't have any of those. So if in fact they would have had an accident and they all passed away at the same time, her money would have gone to the state of New York. So she came in and we put a document together to make sure that if something happened to her and her entire family while they were on a trip, that it would end up going to charities, right? So we did language in her documents that said, this is where I wanted to go. And whenever she got back from her trip, then we changed everything back. But she wanted to make sure that she had it covered. A lot of people don't think about that because they think, I don't care who's going to get my money. Or if you have beneficiaries on it, or it's joint, or it's in a trust, then this intestacy law is not really going to matter because the assets are going to pass as a matter of law. We wouldn't have to probate your will. We wouldn't have to do an administration proceeding. Basically, they're going to go to whomever the beneficiaries are. So the key players in the will, you got your beneficiary, right? That's the person that's going to get your money whenever you pass away, or your car or your house. So cool. I want to be a beneficiary, right? The executor is the person, again, that collects up all the assets and distributes them. The trustee would be someone that you appoint under your will as the person that's going to take care of somebody's money, right? So if the child is underage, or you and your husband pass away together, and you've got a minor child, this is the person that's going to take care of the money. This is the one that's going to make the decisions as to how the money is doled out. So the trustee and executor can be the same person. That's not a problem, right? Because if they have a good head on their shoulders and they know finances, then being the executor and the trustee is a good thing, right? So they can be the same person. Again, you need to make sure that you have backup. We want to have a deep bench. So you want to name your child, and then if your child can't act, your sister or your niece, nephew, we want to try to make sure that we have at least one backup so that if something happens, we have somebody that's going to step up. So what about a guardian? We talked about a guardian earlier in the slide, but we really didn't go into that much depth. The guardian is the person that's going to step up and take care of your kids if they're under 18. Okay, you're like, well, how's that a big deal? It is a big deal, right? Think about it and put yourself in the position of the guardian, right? So let's just say someone asked you to be guardian of their children. I had a friend that lived in New Jersey, and their best friends in the whole world, which they trusted, they had 2 kids of their own, and my friends had 2 kids, and they said, these are the people I want to be my guardian. Not my guardian, the guardian of the kids, obviously. And they lived in an apartment in New York City, right? So how are they going to add 2 kids to that apartment in New York City? It would have been impossible. They would have had to look for a new place to live. By the way, everybody's above age now, not an issue, but they would have had to look for a new place to live. So how are they going to afford that new place to live? Are you going to be able to give them money out of the trust for your children to pay for someplace for them to live? Well, you would think yes, right? Because you want your kids to live someplace safe and have space. So again, when I went back and said it's nice to have a trustee and a guardian that's 2 different people, this is where that kind of comes into play, because you've got a guardian that's saying, hey, we need to move out to the suburbs because now we've got 4 kids. And you've got the trustee saying, well, that makes sense. Let's see what we can do to kind of combine the money together so that we can get something where these kids could be raised. But if you were the guardian and the trustee, obviously you're going to trust this person. But if I've got all this money and I've got 2 new kids, what am I going to do, right? Checks and balances. It's always good to have checks and balances. So when you're thinking about a guardian, you really need to choose well. You need to think about these things. Whenever my son was younger, he's way past 18 now, but whenever he was younger, he's like, well, who would be my guardian, right? If something happened to me. And I said, well, my sister. And he's like, no, I don't want to go live with your sister. And I'm like, Zach, there's nothing wrong with living with my sister. He's like, I don't want to move to Wisconsin. I don't like cheese. Sounds really silly, but think about it. You know, your child has established their life, right? If they're in elementary school, if they're in junior high, especially if they're in high school, right? They have an established life. So what's going to happen, right? Are they going to have to move across the country? Think about their religious beliefs. My friends that lived in New Jersey were Jewish, right? So they were bringing their child up in the Jewish faith. Their friends were not Jewish. So if their children had moved in with their friends, if they passed away, were they going to raise them Jewish, right? Was that a deal breaker for them? That's something to think about, right? So location, religion, oh, I'm going to name my parents, right? I'm going to name my parents as the guardian. Okay, you have a baby right now and your parents are fine with it because they could put them in a bassinet and they can take a nap. What are they going to do with a 2-year-old? What are they going to do with a 3-year-old? What are they going to do with a high school child? Because your parents are getting older as these children get older, right? So they may be able to handle your kids now, but 10 years from now, are they going to be able to handle your kids? You need to think about that. You need to make sure that you have, again, a deep bench of people. If you're going to name your parents, you really need to think about it. You need to think about the ages of your children and the ages of the parent, right? So I told you I was going to name my sister. My sister's stable. So, but is yours stable, right? Are they an artist trying to find themselves? Well, how would they like to find themselves with 2 kids? Not such a good thing. So you need to think about the person that you've appointed as guardian. You need to talk to them and make sure that they're willing to take your children, because that's a big responsibility, right? It's a big responsibility taking somebody else's kids. Location, we already went over. I talked about having a deep bench. And you should relook at your documents every 5 to 10 years, right? So whenever you did your original documents, the kids were 2 years old, you were best friends with Joni and Billy, and you said you'd take their kids. They said they'd take your kids. And 5 years later, you're not friends with them anymore, right? And they probably don't want to take your kids, and you probably don't want to take their kids. So you really need to look at your documents. We tell our clients to look at their documents like every 5 years, just to make sure they still say what they want them to say. I have one client who has changed her trustees and guardianships at least 5 times, right? She has little kids and her people have changed at least 5 times, because originally it was her mom, right? And then her mom had some medical problems, and then it was her sister. And then her sister had some medical problems. And then she had a friend, and then the friend moved away, right? So these are all things you've got to think about it. And you should really dust off your documents and look at them and make sure that they still make sense. Okay, so now that you have your last will and testament done, what next, right? So we've done our will, we have our executor, we have our trustee, we have our guardian, and what are we going to do next? Advanced directives, right? Your healthcare proxy, your living will, your power of attorney, your disposition of remains form. I know, depressing stuff, but think about it. So healthcare. Healthcare proxy is a document that allows someone to make healthcare decisions for you. It has to be signed by 2 disinterested witnesses. What does that mean? It means that whoever you appoint in the healthcare proxy cannot sign the healthcare proxy. This sounds pretty simple, right? But you need to make sure this happens. I've actually had people that have brought documents in where they were named either as healthcare proxy or power of attorney, and they had been a witness. This nullifies the document. So again, witnessed by two disinterested witnesses. As far as your healthcare proxy goes, you may want to scan it into a PDF, put it on your phone. Also, if you're somebody else's healthcare proxy, you may want to scan it in, put it in a PDF on your phone, so that if this person is rushed to the hospital and you have to act on their behalf, you have a copy of the document on your phone. I know a lot of people are doing that with their vaccination cards too. I mean, everybody carries their phones with them. So whether it's a brand new phone or a flip phone, you can put information on phones. So what's a living will? So a healthcare proxy is the person that's going to make healthcare decisions, right? So if you're sitting in your bed, eating your Jell-O and talking to everyone, they're not going to look to the person you've appointed to make your healthcare decisions for you. But if you're incapacitated, they're going to look to the person you've named as healthcare proxy. So the healthcare proxy, healthcare decisions. The living will is end of life, right? End of life, meaning the doctor comes out and says, you're not coming back. And your living will would say, hey, give me good drugs and let me go. Or you can be specific that, you want a certain amount of time to live. Do you want a feeding tube? Do you want hydration? Do you want CPR? These are all things you put in your living will. What you need to understand is that a living will has no teeth. So what does that mean? It means that if you do a living will that says, hey, if the doctor comes out and says, I'm not coming back, give me good drugs and let me go, and the person you've appointed says, no, I've seen her come back from worse than this. Give her everything that you've got. They're going to give you everything that they've got, even though you have a written document that says that you don't want it. So you need to make sure that the person that you appoint as your healthcare proxy understands exactly what your wishes are. The person you appointed for your living will, it understands exactly what your wishes are and will follow your wishes. Because a lot of times it's easy for you just to put names down and then you say something to someone and they're like, oh, no. I had a friend that asked me one time if I would be her healthcare proxy. She'd just lost her spouse and she has a son. And I said, well, what about your son? And she said, well, he's over in Chicago. And I said, well, that's fine. I said, name him as number one and I'll be backup. But your child should be making your decisions. And then she said, well, he told me he can't do what I want him to do. Okay, so at least he was honest, right? So if he can't do what she wants him to do, then that shouldn't be the person, even though it's her son, that she names, right? So make sure you talk to your people, talk to your executor, talk to your power of attorney, talk to your healthcare proxy. Make sure you're all on the same page, because just because you're their closest friend in the whole world and they would do anything for you doesn't necessarily mean that they want to serve for you, right? Power of attorney. Power of attorney is a very, very powerful document. Once you sign it and the person you've appointed signs it, they can do anything that you can do. So what does that mean? They can open accounts, close accounts, change names on accounts, change beneficiaries on accounts, change beneficiaries on retirement accounts, on life insurance. It again has to be signed by two disinterested witnesses. If you're appointed in a person's power of attorney, you cannot be a witness. Same thing with a will, right? If someone's leaving you stuff in the will, you can't be a witness to the will because you automatically void the will or your gifts in the will. Everybody else will get what they're getting, but you won't. So power of attorney, again, has to be witnessed by two disinterested witnesses, and the person who you're doing the power of attorney for has to have capacity to sign. Disposition of remains form. This is a conversation I just had yesterday with a young married couple. And they said that their family tended to step in and take control of things. And they wanted to make sure that their spouse would be able to control things. So I said, well, what you need is a disposition of remains form. It's a really simple form. You can actually download it on the New York State Bar Association website, and it keeps people from fighting over your dead body. I know, laugh, right? It's very specific. It says, this is the person that I want to be in charge. This is what I want. I want to be cremated. I want to be wheeled down the aisle with trumpets blazing and yellow roses. You can be as specific as you want to. You can plan your funeral and put the list on there as to who you went to and where all the information is. This is a really important document if you're in a relationship and you're not married, right? Because they're going to look to your next of kin to make the decision. So if you're dating someone or even living together, and let's just say your parents don't like that person, if you pass away, your parents are going to be in charge of your body. Also, if you're getting a divorce, even though you're in the middle of a divorce, if you're not legally divorced, your ex-spouse to be would be the person who's going to make your decisions as far as where you're going to be buried, if you're going to be cremated. So you need to make sure that you have that in writing, right? So you need a disposition of remains form. So how often should you review your documents? I said earlier, you should review them every 5 years. I've actually had clients that have come in 20 years later, and not only do they not have any changes to their documents, their kids' addresses haven't even changed, which is wild, right? That never happens. My mom used to keep my address in pencil in her book so that she could make sure that she always had a current address for me. So whenever you're looking at your documents, what happens? How often should I look at them? Somebody dies, somebody's born, there's a divorce, someone develops bad habits, someone is not your friend anymore, someone becomes incapacitated and you don't want them to act for you anymore. I mean, things that trigger a review of documents, they're vast, right? It's kind of like whenever something happens to you and you're plugging along and all of a sudden something happens to you and you need to go to the doctors, you really should look at your doctor, go to the doctors, right? Same thing with documents. If something happens in your life or someone else's life, right? Someone passes away that's a beneficiary, where's their share going to go? We try to make our documents as bulletproof as possible so you don't have to change them every 5 years, but you really should dust them off and look at them every 5 years. So this is our last slide. We do offer free consultations. The consultations usually take about an hour. Well, if you already have documents, we'll look at your documents, tell you if they're good, bad, or ugly. We have you fill out what's called a client questionnaire to bring in with you. And then we have estate administration, meaning if someone passes away, we could administer their estate. And if someone has issues, I mean, we're all aging in place. We also do Medicaid applications. We do community Medicaid applications. We do chronic care Medicaid applications, estate administration, estate planning, Medicaid planning. It's better to plan ahead. And like I said, if you answered yes to any of those questions, right? If you're 18 or above, you're in a relationship or married, or if you have minor kids, the time is now to do your estate planning and financial planning too. If you'd like to contact us, I gave you the information to contact us. As you can see, I've been sitting for too long and my light keeps going off. So we also have a radio show on Saturdays from 8 to 9 a.m. on Magic 590. It's a call-in show. You can call in and ask questions, or you can just listen because there's really a lot of good questions that are asked. And a lot of times people have the same questions that you have. Our show is also rebroadcast in Kingston at 7 in the morning and 8 in the morning. If you don't catch it live on Saturday, it's rebroadcast on Sunday. It's been great talking to you, and I hope you can join us for another webinar. We have another one coming up at 2 in the afternoon, and we have a lot of the webinars that are pre-recorded that are on our website at www.herzoglaw.com. You can just sit and watch them at your leisure, right? Kind of like watching Netflix. And we hope that you enjoyed this webinar and you actually learned something, and we hope that you will join us again.